Hello, everyone. The Supreme Court of the United States has decided 9-0 unanimously that the TikTok ban is allowed to go through. There's a lot to it. It's not that long, and since it's such a unanimous and important opinion, I thought we should go through every word of it. So I'm going to read the whole thing. You should know that I'm not in favor of this, but I more want to bring it to you for the educational value of knowing what the law in the U.S. says. The Supreme Court is the final say on what the law of the land is. Ruth Bader Ginsburg once famously said, "We are not final because we are infallible. We are infallible because we are final." In other words, they are the last say as to what the law is, so until the legislature changes the law, which you'll see is not what's going to happen here because this is about a law made by the legislature, then nothing's going to change. So if you disagree with it, vote. That's really the only. I'm not trying to be snarky or sarcastic or mean. That's the only solution if you disagree with what the Supreme Court has ruled and what the legislature has passed and what the president has done. Then you have to just vote. So this is TikTok versus Merrick Garland, the Attorney General of the United States, January 17th, 2025. As of January 19th, the Protecting Americans from Foreign Adversary-Controlled Applications Act will make it unlawful for companies in the United States to provide services to distribute, maintain, or update the social media platform TikTok, unless U.S. operation of the platform is severed from Chinese control. Petitioners are two TikTok operating entities and a group of U.S. TikTok users. We consider whether the act, as applied to petitioners, violates the First Amendment. As applied is a type of constitutional challenge. In doing so, we are conscious that the cases before us involve new technologies with transformative capabilities. This challenging new context counsels caution on our part. As Justice Frankfurter advised 80 years ago in considering the application of established legal rules to the totally new problems raised by the airplane and radio, we should take care not to embarrass the future. That caution is heightened in these cases, given the expedited time allowed for our consideration. Our analysis must be understood to be narrowly focused in the light of these circumstances. Applications for an injunction pending review were filed on December 16th. We construed the applications as petitions for a writ of certiorari and granted them December 18th, and oral argument was held January 10th. Our analysis must be understood to be narrowly focused in light of these circumstances. TikTok is a social media platform that allows users to create, publish, view, share, and interact with short videos overlaid with audio and text. Since its launch in 2017, the platform has accumulated over 170 million users in the United States and more than 1 billion worldwide. Those users are prolific content creators and viewers. In 2023, U.S. TikTok users uploaded more than 5.5 billion videos, which were in turn viewed more than 13 trillion times around the world. Opening the TikTok application brings the user to the For You page, a personalized content feed tailored to the user's interests. TikTok generates the feed using a proprietary algorithm that recommends videos to a user based on the user's interactions with the platform. Each interaction a user has on TikTok, watching a video, following an account, leaving a comment, enables the recommendation system to further tailor a personalized content feed. A TikTok user's content feed is also shaped by content moderation and filtering decisions. TikTok uses automated and human processes to remove content that violates the platform's community guidelines. TikTok also promotes or demotes certain content to advance its business objectives and other goals. TikTok is operated in the United States by TikTok Inc., an American company incorporated and headquartered in California. TikTok's ultimate parent company is ByteDance Limited, a privately held company that has operations in China. ByteDance Limited owns TikTok's proprietary algorithm, which is developed and maintained in China. The company is also responsible for developing portions of the source code that runs the TikTok platform. ByteDance Limited is subject to Chinese laws that require it to assist or cooperate with the Chinese government's intelligence work and to ensure that the Chinese government has the power to access and control private data the company holds. Now, that's an interesting note worth stopping and paying attention to. The Supreme Court notes out of concern here that the Chinese government requires ByteDance to assist or cooperate it, including its intelligence work, whenever it wants to. The same thing with the U.S. government. The U.S. government can issue a warrant at any time. The U.S. government can issue a subpoena at any time. The U.S. government can issue a covert subpoena for intelligence gathering purposes. We had the whole NSA spying on American citizens thing. They can intercept your phone calls and listen in on your phone calls. They don't have to have a warrant for some of these things. So just look in the mirror a little bit while we're reading this thing. In recent years, U.S. government officials have taken repeated actions to address national security concerns regarding the relationship between China and TikTok. In August of 2020, President Trump issued an executive order finding that the spread in the United States of mobile applications developed and owned by companies in China continues to threaten the national security, foreign policy, and economy of the United States. President Trump determined that TikTok raised particular concerns, noting that the platform automatically captures vast swaths of information from its users and is susceptible to being used to further the interests of the Chinese government. No one has ever explained to me how. Please, someone in the comments, tell me how the Chinese government is going to affect the national security of the United States through TikTok. I'm stupid or something. Just tell me I need to know. The president invoked his authority under the International Emergency Economic Powers Act, 50 U.S.C. 1701, and the National Emergencies Act, 50 U.S.C. 1601, to prohibit certain transactions involving ByteDance or its subsidiaries as identified by the Secretary of Commerce. The Secretary published a list of prohibited transactions in September of 2020. But federal courts enjoined the prohibitions before they took effect, finding that they exceeded the executive branch's authority under the IEEPA. Just days after issuing his initial executive order, President Trump ordered ByteDance to divest all interests and rights in any property used to enable or support ByteDance's operation of the TikTok application in the U.S., along with any data obtained or derived from TikTok users. ByteDance and TikTok filed suit in the D.C. Circuit challenging the constitutionality of the order. In February of 2021, the D.C. Circuit placed the case in abeyance to permit the Biden administration to review the matter and to enable the parties to negotiate a non-divestiture remedy that would address the government's national security concerns. Throughout 2021 and 2022, ByteDance negotiated with executive branch officials to develop a national security agreement that would resolve those concerns. Executive branch officials ultimately determined, however, that ByteDance's proposed agreement did not adequately mitigate the risks posed to U.S. national security interests, negotiations stalled, and the parties never finalized an agreement. Against this backdrop, Congress enacted the Protecting Americans from Foreign Adversary-Controlled Applications Act. The Act makes it unlawful for any entity to provide certain services to distribute, maintain, or update a foreign adversary-controlled application in the U.S. Entities that violate this prohibition are subject to civil enforcement proceedings and hefty monetary penalties. The Act provides two means by which an application may be designated a foreign adversary-controlled application. First, the Act expressly designates any application that is operated by ByteDance or TikTok, or any subsidiary or successor thereof. Second, the Act establishes a general designation framework for any application that is both, one, operated by a covered company that is controlled by a foreign adversary, and two, determined by the President, literally POTUS, to present a significant threat to the national security of the United States following a public notice and reporting process. For due process concerns. The Act excludes from that definition a company that operates an application whose primary purpose is to allow users to post product reviews, business reviews, or travel information and reviews. The Act's prohibitions take effect 270 days after an application is designated a foreign adversary-controlled application. Because the Act itself designates applications operated by ByteDance and TikTok, prohibitions as to those applications take effect 270 days from the Act's enactment, January 19, 2025. The Act exempts a foreign adversary-controlled application if the application undergoes a qualified divestiture. A qualified divestiture is one that the President determines will result in the application no longer being controlled by a foreign adversary. The President must further determine that the divestiture precludes the establishment or maintenance of any operational relationship between the United States operations of the application and any formerly affiliated entities that are controlled by a foreign adversary, including any cooperation with respect to the operation of a content recommendation algorithm or an agreement with respect to data sharing. The act permits the president to grant a one-time extension of no more than 90 days with respect to the 270-day effective date if the president makes certain certifications to Congress regarding progress towards a qualified divestiture. ByteDance and TikTok, along with 2 sets of TikTok users, filed petitions for review in the D.C. Circuit challenging the constitutionality of the act. As relevant here, the petitioners argued that the Act's prohibitions, TikTok-specific foreign adversary-controlled application designation, and divestiture requirement violate the First Amendment. And I have another idea too, but we'll talk about that at the end. The D.C. Circuit consolidated and denied the petitions, holding that the Act does not violate petitioners' First Amendment rights. After first concluding that the Act was subject to heightened scrutiny under the First Amendment, the court assumed without deciding that strict rather than intermediate scrutiny applied. These are the standards for evaluating constitutional issues. So, like, the First Amendment gets the highest level of scrutiny, the most attention, the most analysis, and the strictest requirements for it to be valid. The other things like the prohibition of alcohol, for example, don't touch on a human right, so they don't get this heightened level of scrutiny. They need a much lower level of connection between the law and its effects and the government's ability and jurisdiction to do it than does a First Amendment issue, for example. The court held that the Act satisfied that standard, finding that the government's national security justifications were compelling and that the Act was narrowly tailored to further those interests. Compelling and narrowly tailored are part of strict scrutiny. The Chief Judge conferred in part and in the judgment. In his view, the Act was subject to intermediate scrutiny and was constitutional under that standard. We granted certification to decide whether the Act, as applied to petitioners, violates the First Amendment. At the threshold, we consider whether the challenged provisions are even subject to First Amendment scrutiny. Laws that directly regulate expressive conduct can, but do not necessarily trigger such review. We have also applied First Amendment scrutiny in cases involving government regulation of conduct that has an expressive element, and to some statutes which, although directed at activity with no expressive component, impose a disproportionate burden upon those engaged in protected First Amendment activities. It is not clear that the Act itself directly regulates protected expressive activity or conduct with an expressive component. Indeed, the Act does not regulate the creator petitioners at all, and it directly regulates ByteDance and TikTok only through the divestiture requirement. Petitioners, for their part, have not identified any case in which this court has treated a regulation of corporate control as a direct regulation of expressive activity or semi-expressive conduct. We hesitate to break that new ground in this unique case. In any event, petitioners' arguments are more closely approximate to a claim that the Act's prohibitions and divestiture requirement impose a disproportionate burden upon their First Amendment activities. So a disproportionate burden on First Amendment activities. Petitioners assert, and the government does not contest, that because it is commercially infeasible for TikTok to be divested within the Act's 270-day timeframe, the Act effectively bans TikTok. Petitioners argue that such a ban will burden various First Amendment activities, including content moderation, content generation, access to a distinct medium for expression, association with another speaker or preferred editor, and receipt of information and ideas. Don't forget the First Amendment's freedom of association as well. We have recognized a number of these asserted First Amendment interests. An entity exercising editorial discretion in the selection and presentation of content is engaged in speech activity. Our prior decisions have voiced particular concern with laws that foreclose an entire medium of expression. We have recognized a First Amendment right to associate for the purpose of speaking, which we have termed the right of expressive association, and the right of freedom of speech and press embraces the right to distribute literature and necessarily protects the right to receive it. And an effective ban on a social media platform with 170 million U.S. users certainly burdens those users' expressive activity in a non-trivial way. To the extent that ByteDance's asserted expressive activity occurs abroad, that activity is not protected by the First Amendment. Foreign organizations operating abroad have no First Amendment rights. At the same time, a law targeting a foreign adversary's control over a communications platform is in many ways different in kind from the regulations of non-expressive activity that we have subjected to First Amendment scrutiny. Those differences, the Act's focus on a foreign government, the congressionally determined adversary relationship between that foreign government and the United States, and the causal steps between the regulations and the alleged burden on protected speech may impact whether First Amendment scrutiny applies. This court has not articulated a clear framework for determining whether a regulation of non-expressive activity that disproportionately burdens those engaged in expressive activity triggers heightened review. We need not do so here. We assume without deciding that the challenged provisions fall within this category and are subject to First Amendment scrutiny. At the heart of the First Amendment lies the principle that each person should decide for himself or herself the ideas and beliefs deserving of expression, consideration, and adherence. Government action that suppresses speech because of its message contravenes this essential right. Content-based laws, those that target speech based on its communicative content, are presumptively unconstitutional and may be justified only if the government proves that they are narrowly tailored to serve compelling state interests. That's the heightened scrutiny standard. The regulation must be narrowly tailored to serve compelling state interests, and there are further definitions for those terms defined in case law. Content-neutral laws, in contrast, are subject to an intermediate level of scrutiny because in most cases they pose a less substantial risk of excising or removing certain ideas or viewpoints from the public dialogue. Under that standard, we will sustain a content-neutral law if it advances important government interests unrelated to the suppression of free speech and does not burden substantially more speech than necessary to further those interests. That's intermediate scrutiny. We have identified two forms of content-based speech regulation. First, the law is content-based on its face. If it applies to particular speech because of the topic discussed or the idea or message expressed, this would be considered a viewpoint-based constraint. Second, a facially content-neutral law is nonetheless treated as a content-based regulation if it cannot be justified without reference to the content of the regulated speech or was adopted by the government because of disagreement with the message the speech conveys. As applied to petitioners, the challenged provisions are facially content-neutral and are justified by a content-neutral rationale. The challenged provisions are facially content-neutral. They impose TikTok-specific prohibitions due to a foreign adversary's control over the platform and make divestiture a prerequisite for the platform's continued operation in the United States. They do not target particular speech based on its content. Contrast Carey v. Brown, a statute prohibiting all residential picketing except for peaceful labor picketing, or regulate speech based on its function or purpose. Contrast Holder v. Humanitarian Law Project, a law prohibiting providing material support to terrorists. Nor do they impose a restriction penalty or burden by reason of content on TikTok, a conclusion confirmed by the fact that petitioners cannot avoid or mitigate the effects of the act by altering their speech. As to petitioners, the act thus does not facially regulate particular speech because of the topic discussed or the idea or message expressed. So the court concludes the act is viewpoint neutral because there is no viewpoint you could change that would change the outcome of the act. Petitioners argue that the act is content-based on its face because it excludes from the definition of covered company any company that operates an application whose primary purpose is to allow users to post product reviews, business reviews, or travel and information reviews. We need not decide whether that exclusion is content-based. The question before the court is whether the act violates the First Amendment as applied to petitioners. To answer that question, we look to the provisions of the act that give rise to the effective TikTok ban that petitioners argue burdens their First Amendment rights. The exclusion for certain review platforms, however, applies only to the general framework for designating applications controlled by covered companies, not to the TikTok-specific designation. As such, the exclusion is not within the scope of the petitioner's challenge. So they said before that this is a two-part law. It targets TikTok directly, and it also targets these large platforms of 1 million users controlled by an adversary government. So it's not that second part, so we're just sticking with the first part, and therefore that's not viewpoint-based. It may be something else, but it's not viewpoint-based, according to the court. The government also supports the challenged provisions with a content-neutral justification preventing China from collecting vast amounts of sensitive data from 170 million U.S. TikTok users. That rationale is decidedly content agnostic. It neither references the content of speech on TikTok nor reflects disagreement with the message such speech conveys. Because the data collection justification reflects a purpose unrelated to the content of expression, it is content neutral. The Act's TikTok-specific distinctions, moreover, do not trigger strict scrutiny. It is true that speech restrictions based on the identity of the speaker are all too often simply a means to control content. See Citizens United. For that reason, regulations that discriminate among media or among different speakers within a single medium often present serious First Amendment concerns. But while laws favoring some speakers over others demand strict scrutiny when the legislature's speaker preference reflects a content preference, such scrutiny is unwarranted when the differential treatment is justified by some special characteristic of the particular speaker being regulated. For the reasons we have explained, requiring divestiture for the purpose of preventing a foreign adversary from accessing the sensitive data of 170 million U.S. TikTok users is not a subtle means of exercising a content preference. The prohibitions, TikTok-specific designation, and divestiture requirement regulate TikTok based on a content-neutral data collection interest. And TikTok has special characteristics, a foreign adversary's ability to leverage its control over the platform to collect vast amounts of personal data from 170 million U.S. users, that justify this differential treatment. Speaker distinctions of this nature are not presumed invalid under the First Amendment. While we find that differential treatment was justified here, however, we emphasize the inherent narrowness of our holding. Data collection and analysis is a common practice in this digital age, but TikTok's scale and susceptibility to foreign adversary control, together with the vast swaths of sensitive data the platform collects, justify differential treatment to address the government's national security concerns. A law targeting any other speaker would, by necessity, entail a distinct inquiry and separate considerations. On this understanding, we cannot accept petitioners' call for strict scrutiny, no more than intermediate scrutiny is in order. As applied to petitioners, the Act satisfies intermediate scrutiny then. The challenged provisions further an important government interest, unrelated to the suppression of free expression, and do not burden substantially more speech than necessary to further that interest. Our holding and analysis are based on the public record without reference to the classified evidence the government filed below. The Act's prohibitions and divestiture requirement are designed to prevent China, a designated foreign adversary, from leveraging its control over ByteDance to capture the personal data of U.S. TikTok users. This objective qualifies as an important government interest under intermediate scrutiny. So if you're lost, the law specifically targets TikTok. The law gives power to the President of the United States to designate a foreign adversary-controlled application and basically ban it, and then 270 days later it's banned if it doesn't sell itself in a way that satisfies everyone that the Chinese government's not control of it anymore. You got that? So then TikTok is arguing that its First Amendment rights have been violated. It does have First Amendment rights. U.S. corporations have First Amendment rights. So if it can get this strict, heightened scrutiny for a First Amendment violation, then it's much easier for it to win its case. But the court's not going to let it have that. The court is going to use intermediate scrutiny, which is a lesser standard that makes it easier for the government to win its case. Petitioners do not dispute that the government has an important and well-grounded interest in preventing China from collecting the personal data of tens of millions of U.S. TikTok users, nor could they. The platform collects extensive personal information from and about its users. Public reporting has suggested that TikTok's data collection practices extend to age, phone number, precise location, internet address, device used, phone contacts, social network connections, the content of private messages sent through the application, and videos watched. It includes keystroke patterns and rhythms. It includes device contacts and calendars. If a user allows TikTok access to the user's phone contact list to connect with others, TikTok can now access any data stored in the user's contact list, including names, contact information, contact photos, job titles, and notes. Access to such detailed information about U.S. users, the government worries, may enable China to track the locations of federal employees and contractors, build dossiers of personal information for blackmail, and conduct corporate espionage. Of course, that statement is made in a vacuum, like as if the federal government is going to allow its employees to put TikTok on their business or personal phones and walk around using it while in federal government facilities or something like that. I mean, okay, yeah, there's some kind of a concern, but it's a concern that can be addressed by training your own people. This seems like a kind of burn it all down answer to a small problem. And Chinese law enables China to require companies to surrender data to the government, making companies headquartered there an espionage tool. I mean, So does the U.S. The U.S. requires American companies to turn over data on their users as well. And sometimes they're with secret warrants that you don't get to see, especially when it's a criminal complaint in nature. It's a well-known thing that the U.S. government does this exact same thing. Rather than meaningfully dispute the scope of the data TikTok collects or the ends to which it may be used, petitioners contest the probability, asserting that it is unlikely that China would compel TikTok to turn over its user data for intelligence gathering purposes, since China has more effective and more efficient means of obtaining the information. Wow, way to say the quiet part out loud. We don't need TikTok. We've got more effective ways of tracking you and getting your information. Wonderful. In reviewing the constitutionality of the act, however, we must accord substantial deference to the predictive judgments of Congress. Sound policymaking often requires legislatures to forecast future events and to anticipate the likely impact of those events based on deductions and inferences for which complete empirical support may be unavailable. The court is saying they expect Congress to do their job. I think the Supreme Court has red flag knowledge that the Congress does not do its job, and the Supreme Court should have taken a better position here. Here, the government's TikTok-related data collection concerns do not exist in isolation. The record reflects that China has engaged in extensive and years-long efforts to accumulate structured data sets, in particular on U.S. persons, to support its intelligence and counterintelligence operation. Even if China has not yet leveraged its relationship with ByteDance for U.S. TikTok users' data, petitioners offer no basis for concluding that the government's determination that China might do so is not at least reasonable inference based on substantial evidence. We are mindful that this law arises in a context in which national security and foreign policy concerns arise in connection with efforts to confront evolving threats in an area where information can be difficult to obtain and the impact of certain conduct difficult to assess. We thus afford the government's informed judgment substantial respect here. That's where we are. The U.S. Supreme Court is saying that the people you elect to Congress are the ones who make these decisions, and you don't have to like it. Like, if you don't like it, vote. Petitioners further argue that the act is under-inclusive as to the government's data protection concern, raising doubts as to whether the government is actually pursuing that interest. Petitioners argue that the act's focus on applications with user-generated and user-shared content, along with its exclusion for certain review platforms, exempts from regulation applications that are as capable as TikTok of collecting Americans' data. But the First Amendment imposes no freestanding under-inclusiveness limitation, and the government need not address all aspects of a problem in one fell swoop. Furthermore, as we have already concluded, the government had a good reason to single out TikTok for special treatment. On this record, Congress was justified in specifically addressing its TikTok-related national security concerns. As applied to petitioners, the act is sufficiently tailored to address the government's interest in preventing a foreign adversary from collecting vast swaths of sensitive data about the 170 million U.S. persons who use TikTok. To survive intermediate scrutiny, a regulation need not be the least speech-restrictive means of advancing the government's interests. Rather, the standard is satisfied so long as the regulation promotes a substantial government interest that would be achieved less effectively absent the regulation, and does not burden substantially more speech than is necessary to further that interest. The challenged provisions meet this standard. Provisions clearly serve the government's data collection interest in a direct and effective way. The prohibitions account for the fact that, absent a qualified divestiture, TikTok's very operation in the United States implicates the government's data collection concerns, while the requirements that make a divestiture qualified ensure that those concerns are addressed before TikTok resumes U.S. operations. Neither the prohibitions nor the divestiture requirement, moreover, is substantially broader than necessary to achieve this national security objective. Rather than ban TikTok outright, the act imposes a conditional ban. The prohibitions prevent China from gathering data from U.S. TikTok users unless and until a qualified divestiture severs China's control. Petitioners parade a series of alternatives: disclosure requirements, data sharing requirements, the proposed national security agreement, the general designation provision, that they assert would address the government's data collection interest in equal measure to a conditional ban. Those alternatives do not alter our analysis. Petitioners' proposed alternatives ignore the latitude that we afford to the government to design regulatory solutions to address content-neutral interests. In other words, TikTok doesn't get to design the solution, the Congress does. So long as the means chosen are not substantially broader than necessary to achieve the government's interest, the regulation will not be invalid simply because a court concludes the government interest could have been adequately served by some less speech-restrictive alternative. For the reasons we have explained, the challenge provisions are not substantially broader than necessary to address the government's data collection concerns, nor did the government ignore less restrictive approaches already proven effective. The validity of the challenge provisions does not turn on whether we agree with the government's conclusion that its chosen regulatory path is best or most appropriate. We cannot displace the government's judgment respecting content-neutral regulations with our own, so long as its policy is grounded on reasonable factual findings, supported by evidence that is substantial for a legislative determination. Those requirements are met here. I don't know. You can decide for yourself whether you agree with the Supreme Court, but I do not find that they made reasonable factual findings supported by evidence. So far, we're halfway through, we're 17 pages into this thing, and I haven't heard what the national security concern is. I'm not sure what the national security concern is here, because I do actually believe that China has many better ways of getting information on the locations and habits of Americans if they wanted to. I'm also not entirely sure what the strategic advantage is here, the national security advantage is here. But I mean, I guess if you wanted to say there's a non-zero chance that China could use it to a national security advantage, okay, I'll admit that there's probably more than a zero chance that the Chinese government could somehow benefit in a national security way, having a national security advantage over the United States or something. This is a really weird way to do that. There are many bigger cracks in the system, and there are many other ways to get access to people that TikTok just seems like an easy target. And a convenient one, considering there are competing social networks based out of the US that would love to see that traffic come back to their platforms. In addition to the data collection concerns addressed above, the government asserts an interest in preventing a foreign adversary from having control over the recommendation algorithm that runs a widely used U.S. communications platform from being able to wield that control to alter the content on the platform in an undetectable manner. What, did you just figuring out YouTube? Like, the YouTube algorithm screws us all over too, but you didn't have a problem with that. In petitioners' view, that rationale is a content-based justification that taints the government's data collection interests and triggers strict scrutiny. I don't know. I personally think the government has an ulterior motive and is not acting in a sincere and genuine way out of a sincere national security interest, but rather, I think, economic protectionism, protecting Facebook and YouTube and, I guess, X from the competition that TikTok brings. That's what I think this is really about. I think they are not saying the quiet part out loud, and they are making a 9-0 unanimous opinion to try and cover up the fact that this is simply economic nationalism, economic protectionism. Petitioners have not pointed to any case in which this court has assessed the appropriate level of First Amendment scrutiny for an act of Congress justified on both content-neutral and content-based grounds. They assert, however, that the challenge provisions are subject to and fail strict scrutiny because Congress would not have passed the provisions absent the foreign adversary control rationale. We need not determine the proper standard for a mixed justification case or decide whether the government's foreign adversary control justification is content neutral. Even assuming that rationale turns on content, petitioners' argument fails under the counterfactual analysis they propose. The record before us adequately supports the conclusion that Congress would have passed the challenge provisions based on the data collection justification alone. To start, the House report focuses overwhelmingly on the government's data collection concerns, noting the breadth of TikTok's data collection, the difficulty in assessing precisely which categories of data the platform collects, and tight interlinkages between TikTok and the Chinese government, and the Chinese government's ability to coerce companies in China to provide data. Indeed, it does not appear that any legislator disputed the national security risks associated with TikTok's data collection practices, and nothing in the legislative record suggests that data collection was anything but an overriding congressional concern. We are especially wary of parsing Congress's motives on this record with regard to an act passed with striking bipartisan support. Petitioners assert that the text of the act itself undermines this conclusion. They argue that the government's data collection rationale cannot justify the requirement that a qualified divestiture preclude any operational relationship that allows for cooperation with respect to the operation of a content recommendation algorithm or an agreement with respect to data sharing. We disagree. The government has explained that ByteDance uses the data it collects to train the TikTok recommendation algorithm, which is developed and maintained in China. According to the government, ByteDance has previously declined to agree to stop collecting U.S. user data or sending that data to China to train the algorithm. The government has further noted the difficulties associated with monitoring data sharing between ByteDance and TikTok. Under these circumstances, we find the government's data collection justification sufficient to sustain the challenged provisions. There is no doubt that for 170 million Americans, TikTok offers a distinctive and expansive outlet for expression, means of engagement, and source of community. But Congress has determined that divestiture is necessary to address its well-supported national security concerns regarding TikTok's data collection practices and relationship with a foreign adversary. For the foregoing reasons, we conclude that the challenged provisions do not violate petitioners' First Amendment rights. The judgment of the United States Court of Appeals is affirmed. So the bill was written directly to address TikTok. The bill was written to give the president the power to designate a foreign adversary-controlled application and require its divestiture. The bill apparently doesn't touch on anyone's First Amendment right of freedom of expression or freedom of association. And the bill is definitely not an illegal attempt at national economic protectionism, favoring X or YouTube or Facebook so that those platforms don't have as much competition from a foreign-controlled application. I also thought of the Bill of Attainder. A bill of attainder is when the legislature declares by act, by law, that a person or group of people, which would include companies, are guilty of something and then provides a punishment without a trial. This looks an awful lot like that. I don't entirely understand why the Supreme Court did not address bills of attainder. Maybe it wasn't brought up. Maybe it was thrown out on a lower ruling. Maybe TikTok did not bring it up. But a bill directly addressing TikTok, an American company, declaring that it is a thing and then providing for a punishment unless they divest, that just seems like an illegal bill of attainder to me. Obviously, the Supreme Court 9-0 does not agree with me. Obviously, I'm wrong in the sense that other people have decided that I'm wrong. But I think in the greater philosophy of law, hiding behind national security when what you really want is the money to stay in the country, so you make an illegal bill of attainder, and you don't want it to be unconstitutional, so you make your bill of attainder conditional upon something so that you can later say it wasn't really a bill of attainder. I think this is just a bunch of clever legal maneuvering to get TikTok banned so that Facebook, X, and YouTube can benefit. I professionally don't believe that this is actually about national security. I could hear an argument, but I don't. Nobody's told me. I understand that I'm not national security, that I'm not security clearance, that I'm not inside the intelligence community. And I just feel really stupid though. Like, okay, we don't want China to have our plans for war or our plans for country defense. Okay, we don't want them to have access to emptying people's bank accounts through like glitches and things like that. Don't see how TikTok is connected to any national security concern. If your national security concern is TikTok could track users, yeah, everybody does that. So why is TikTok the one? The court gave a lot of leeway and said, well, fine, you can start with TikTok and you don't have to do anything more. And that's okay. I don't agree that that's okay. I think calling out one platform and saying it's not okay for you to do what everybody else is doing, I don't agree with that. But you can let me know the difference below. Maybe it is just because it's China. Maybe it would sound different to my ears if it was a Russian social media platform or video content distribution platform with a Russian algorithm or something. I don't know. And I don't doubt that China could try to sabotage the US. I just don't see how they're doing it through a social media video platform. What? They're going to just change the platform instantly to have propaganda videos one day, and Americans are just going to activate like sleeper cells and turn on their country? I don't understand. Somebody please explain this to me in the comments below. And let me know what you think more largely about a TikTok ban, and whether you believe a TikTok ban is just a cover for redistributing the users onto other platforms. Me personally, I feel like if it walks like a duck and quacks like a duck, it might just be a duck.